Fabulous.
If that is even a thing.
Okay, so we can go ahead and get started. I am in the chat, gonna go ahead and throw in, I already threw in the chat, so hopefully those of you can see it. A link to any previous recorded clinics that we do have. I've had some questions and comments about wanting to see those. And I also just threw in the chat the pre-test for the session. Just as a reminder, please mute yourself. And we do like seeing faces. So if you're able to be on camera, more than happy, but we also understand that's not always feasible for people. So feel free to not be if that's best for you. As far as I will be monitoring the chat during this session, if you can go ahead and throw your name and organization in the chat, that would be great for us to kind of keep track. And then also during the session, we are excited to today have Dr. McLean talk about, law and ethics for us. This is definitely a topic that comes up a lot, so we will be covering that. But if you have questions while Dr. McLean is presenting, feel free. We want to create this as a community atmosphere as if you were in person. So feel free to take yourself off mute and at a convenient time, ask the question. That is perfectly feasible. Or you can type the question into the chat and I will choose a time to ask Dr. McLean that question as we go. So with that, I am going to turn it over to Dr. McLean for him to provide a short introduction for himself and to get us started with the session.
Okay, thanks, Rebecca. So I'm Andy McLean. I'm the chair of the Department of Psychiatry and Behavioral Science for the med school here in North Dakota. Prior to that, I was the medical director for the North Dakota Department of Human Services. So I'm going to go ahead and hopefully share the screen. And can everybody see this okay?
Yes.
Okay.
However, you're on the... Yeah, you're where we see the little ones on the side.
Okay,
Perfect.
Do you see the big screen now?
Yep, that is perfect.
Okay, super. So typically with an echo format, we do a presentation X amount of time, sometimes varies, sometimes anywhere between 15 minutes to 45 minutes. But I'll try to keep this to about a half an hour. Then if there are particular cases that people want to talk about, we can do that and have a discussion, being mindful that we want to make sure that we protect confidentiality and any protected health information. So we'll go ahead and get started. So we want to understand the difference between law and ethics. Talk about the fact that each state has their own laws and requirements. We know that there are particular standards of practice, but every state has their own laws. And then take a look at the difference between public health ethics and clinical ethics issues. So when we talk about laws, we're looking at a system of binding rules. So it's if the laws aren't followed, there could be penalties, civil or criminal. Ethics is more of a system of moral principles. And oftentimes we look at that from our own practices, our own professional standards of care. And it's usually should, but difficult to enforce versus legal issues. And as we well know, not all ethical issues are legal and not all legal issues are ethical. And so when we look at, again, the differences, law, we must do, ethics, we should do. And then when we talk about morals, we're oftentimes talking about individual ethos. And when we're talking about societal issues, we're talking about ethics in general, just in terms of those terminologies. So one of the big differences in public health versus clinical individual ethics has to do with what is good for the individual versus what is good for the community. The public health ethics on the left side are actually more in common with what other, perhaps European and perhaps the Eastern, the Orient actually looks at. It's more interdependence, versus in the US, looking at clinical ethics, that's more independent. So it's, the importance in the US tends to be the individual. The importance in other areas of the world and in public health ethics has to do with the common good. And so the issue is maximizing group well-being, social justice over autonomy, public benefit over individual well-being, and then there are typically uniform compulsory measures. Clinical ethics, which most of us are better acquainted with, have to do with the clinician-patient relationship, promoting individual well-being. As we know in medical ethics, autonomy is probably the most important element. The good is individually determined, and again, everything is individualized. And we try to avoid coercion, compulsion, etc. So one of the things we think about in terms of, whose agent are we in terms of relationships, typically the provider-patient or client relationship, there's a duty, there's an understanding within that relationship that we owe them, good faith and good care. We can breach that when there are concerns of safety for a particular individual or group. And many of you have heard the term Tarasoff, which had to do with safety to a particular individual. An individual was actually killed, and there were cases, there were a number of different cases around that, looking at whether or not there was duty to protect, duty to warn, and we'll talk about that in particular. And then, we also have exceptions with mandatory reporting for other areas like elder abuse, child abuse, other safety concerns. And then we all know about rules of reportable diseases, and we'll be talking about that as well. So we want to know, when we're trying to sort out when we learn of information, usually it's pretty straightforward. We know that this is our patient or our client. There are other times where it's a bit more sketchy. So, typically you would have an agreement that's either express or implied that the individual has the capacity to consent to contract, and that there's, an agreement of what you are treating them for. So when we are looking at trying to shape behavior or looking at particular types of behaviors, whether clients or patients, some of the things that we look at and talk about are, motivational interviewing, trying to move people towards their goals, and assuming that the goals are mutually agreed upon, shared decision-making, where input is provided by both the client, the patient, and also the provider, standard of care. And most places have similar standards of care. Many years ago, there used to be different standards within particular regions or locations, but most specialties now and disciplines all do standardized tests, they do standardized education, and we don't see those regional differences much anymore outside of particular state laws. And then the other considerations that we are talking about is, from what we learn, is this a mandated issue that we need to report? And then there are also the particular laws within each state. For North Dakota, it's the Century Code. I assume many of you are from North Dakota. And so when we're looking at different issues in terms of mandatory reporting and forced treatment, TB Sanatorium had been in San Haven, North Dakota. It closed many, many years ago, but most states had TB sanatoriums, and it was mandated that people actually go there and receive treatment. There's actually, for a brief period of time in the early 1920s, roughly, the Lemoore Trachoma Hospital. And that actually was another infectious disease concern. Trachoma is caused by a bacteria that causes significant infection in the eyes, leading to blindness. And there were outbreaks around the country, and many states had hospitals. The Lemoore Trachoma Hospital, I think, was actually a house, and I think it was open for about 5 years or so. Then we have the North Dakota State Hospital. We have the North Dakota Developmental Center, which is now the Life Skills Training Center. And so those, a couple of those institutions obviously are still in place. Interestingly, when we talk about individual rights, there was a time where a number of states had compulsory sterilization for quote unquote the feeble-minded. Interestingly, I had surveyed a hospital in California, and that hospital had been in communication with the German government in the late 1930s, and they were wanting to learn more about California's mandated compulsory sterilization, and we know what happened with Nazi Germany. There are also other places, the Hiawatha Insane Asylum for Indians, which was in Canton, South Dakota, and that actually closed in the mid-1930s. And so we have a history, you know, within the state and regionally on issues of forced treatment and eventually some closures of those. So one of the things that we're talking about in terms of what we can divulge if we're mandated reporters, the differences between confidentiality and privilege. So things which are confidential are assumed that a clinician has a duty to hold patient-client information confidential. That's actually a bit different than privileged information. So privileged information is by special status. So, you know, a medical staff executive committee, medical licensing board reviews. So what this means is that the courts cannot actually force that to be divulged. Versus confidentiality, the courts can actually force you to report confidential information. So all privileged information is confidential. Not all confidential information is privileged. So the privilege has to do with essentially, can the court actually mandate you to divulge? Other relationships, privileged information, clergy and penitent, spouses, you don't have to testify against your spouse. Some of you might want to, but you don't have to. Then attorney-client privileges, which we're very well acquainted with as well. So one of the things that we struggle with when we're looking at being asked to divulge something or do something that's different from the doctor-patient or practitioner-patient relationship is, you know, recognizing dual agency. And so that's when you're wearing a number of different hats, and you may be beholden to some other organization or individual other than your client. And so we want to be aware of those potential conflicts of interest. And we want to be mindful of how we know that. And so sometimes that's important to have a colleague to bounce things off of, to say, I got this situation here. I'm not exactly sure what I should do. What do you think? We also, most of us have legal counsel somewhere within our organizations. But I'll give you an example of dual agency with what I used to run into a fair amount of time. I would treat individuals who may have had disabilities. And the court would say, we are appointing you, Dr. McLean, as the expert examiner for this patient. Well, that was a potential conflict of interest, because I was beholden to the patient. I was that patient's doctor, and I wasn't an agent of the court. So I would either have to choose to say, Your Honor, I'm not going to do this, or I would have a conversation with the patient and explain things and say, this is what I'm being asked. This is the likely outcome. Would you like me to go ahead and do so? And so I think the important thing is, when we know of conflicts, we want to be transparent about that and make sure that we're going in the right direction. At the end, I'll talk about how we might be able to deal with this. So, as I mentioned, there are circumstances where it's in the public best interest to, to go beyond the confidentiality of a patient. Or at least we have to recognize that there might be some duty. So duty to warn and duty to protect. One of the things we want to look at is there significant risk of harm to an identified individual? And if so, you have an obligation to take reasonable steps to either warn or protect. So what does this mean? Duty to warn is essentially breaching confidentiality by notifying a third party of potential imminent danger or harm. So that might be calling the police. It might be contacting the particular individual that you feel is at risk. So it's essentially breaching, confidentiality, quote unquote, patient rights to try to ensure safety. The other, duty to protect, is where you don't breach that confidentiality, but you ensure safety, typically by protecting a third party through hospitalization, significant wraparound services, treatment, other clinical interventions. So that's what they mean with the phrase duty to warn or duty to protect. Duty to warn, you're actually breaching confidentiality. Duty to protect, you're essentially providing a holding environment that allows for others to be safe. So the term terrace off, as mentioned, came from a case in which a young woman was killed, and it was essentially the parties were found to be not guilty, the providers, but then it was rechallenged, and they felt that there should have been a duty to warn and duty to protect. Interestingly, they actually had contacted law enforcement who did a welfare check, but that wasn't sufficient. So when a therapist determines, or pursuant to the standards of their profession should determine, that the patient presents a serious danger of violence to another, we can do either a duty to warn or duty to protect. And there are state-by-state rules. So for example, in North Dakota, there's actually not a duty to protect or duty to warn. And I certainly, I've trained many individuals, including clinicians, medical students, residents, and that doesn't mean you do nothing. It simply means that the legislature has not put in statute what you should do, but we all have standards of practice and standards of care. In North Dakota, if you have an identified individual at risk, or know of an individual that you're seeing who is going to do imminent harm or harm in the near future, then we certainly have an obligation, an ethical obligation, if not the legal obligation, to either protect or to warn. So some of the things that we look at is, is there a foreseeable risk? Do we know when we're treating a patient who says, no, I'm not going to get treatment, and I know, I'm infected, and I've got this partner, and I'm not going to say anything, or I'm going to intentionally do something. What is foreseeable? What is dangerous? Is there a sense of a fairly urgent time frame, as opposed to, in about a year, if this doesn't clear up, I might do something, blah, blah, blah. And then, do we have an obligation to the general public? Are we recognizing that we're at a point where we might need to breach confidentiality? And what would be reasonable? What would be a standard of care, a reasonable step or action? So when we look at North Dakota mandated reporting laws, particularly looking at infectious disease, we know that the following conditions are to be reported within 7 days of diagnosis. These areas here: chlamydia, gonorrhea, Hep B, chronic, Hep C, HIV, syphilis, and tuberculosis. And there are several immediate reporting conditions: hepatitis A, hepatitis B acute, pregnancy in an HIV individual, positive individual, pregnancy in a hepatitis B positive individual, active tuberculosis. And so those are mandated reports immediately to the Department of Health. We do those reports by one of the following: online reporting, calling, sending in information via fax, etc. But all of this information can be found on the North Dakota Department of Health website. North Dakota Department of Human Services and Department of Health just merged, so it may be called a different site, but it's easily findable. And every other state will have a similar reporting access site as well. So when do we have to report, and who must? Well, healthcare providers, physicians, hospitals, healthcare facilities, if you're a practitioner, licensed addiction counselor who's treating someone with a particular addiction concern, and you come across information, we would be mandated reporters because we're healthcare providers who is either diagnosing or treating. Teachers have to report suspected cases. So within the school, a principal or teacher in any setting, whether it's private, parochial, et cetera, has to report to the Department of Health. And then, labs are required to report any lab result, which may be interpreted as indicative of any reportable condition, to the Department of Health as well. So when we give information to the Department of Health, we are required to give protected health information, which goes against the typical confidentiality, protected health information rights of the individual. So patient demographics, clinical information, risk history, and the facility information. Oftentimes clinicians are worried, well, now, and the patients or the clients are obviously worried, well, this is going to be spread all over the place now because you're going to breach my confidentiality. Well, actually what happens is the North Dakota Department of Health will receive that information. They will, track down any individuals as far as risk. However, when they are also mandated to forward that information to the Centers for Disease Control, they pass information that's de-identified. So identified information doesn't go beyond the Department of Health. Even though the statistics are forwarded on, they are anonymous to the CDC. So here's a question for the group. If you're a mandated reporter, are there any circumstances in which you wouldn't tell the individual that you're reporting? And I'm a psychiatrist, so I can sit patiently in silence for a long time. Rebecca, you're muted.
We have in the chat when it could compromise their safety, the safety of the patient and or the safety of clinician.
That's exactly right. Yeah, we have to gauge the situation. And so if you feel that you are at risk in divulging to the individual that you're mandated to report and you're going to report, then I think it's very reasonable and wise to delay telling the individual until it's a safe situation. Most of the time, we have paperwork when we start to treat a patient that, they sign that they're aware that there are some conditions that, are mandated reporting, et cetera. But oftentimes we find ourselves in that situation with the patient or the client where, oh, I guess I have to now indicate that I'm a mandated reporter and I'm going to report this. Hopefully you have a relationship where, and Wanda mentions open, honest communication. But there are times where there might be a point of danger in doing so. But most of the time we do communicate that, and most of the time people recognize that we are mandated reporters. So whenever we can avoid finding ourselves in that situation and try to prepare patients as they come in, or individuals when they come in for treatment, that they're aware of what the rules are, that's all the better. But, certainly we have found ourselves in situations where we've waited until it was a safe situation. So forced treatment or forced compliance, when is it justified? Are there alternatives even if criteria is met? What are the implications if an alternative is used and there's a negative outcome? We'll talk a little bit about the medical legal sorts of issues there. The decision makers in forced treatment tend to be those having to do with the laws, judges, public health officials, obviously. COVID was a bit of a mess in terms of public health officials trying to mandate certain safe practices and treatment, administrators, patients and advocates, practitioners, and others. So just a reminder here in terms of mandated reporting, this is the site that you go to for infectious disease. There are also other mandatory reportable conditions that are not infectious disease issues. There's actually mandated reporting for this panel here. There was quite a disagreement among mental health practitioners in the need to report suicide and suicide attempts. There came to an agreement that the spirit of what the Department of Health was looking for were those urgent situations and oftentimes attempts, i.e. people landing in the ER, et cetera, where it was, imminent or an overt attempt. And the reason for these other clusters here was to essentially gather data to be able to ask for funding that would be necessary to treat these conditions that otherwise didn't receive adequate resources. But many of you have been in the situation of having to report these and maybe being a bit reluctant to do so. So when we talked about, when you're making your decision about whether you report or not, probably the most helpful piece of information I ever learned in residency was when you're stuck, you expand the field. So you shouldn't have to feel that you are the only individual dealing with this situation at this moment in time. Sometimes you do have to make the call, but oftentimes, you have the ability to take a couple of minutes and check with a colleague, run it by somebody else. The other important thing is, and let me jump down to before I put, talk about documentation. There's something called omission of fact versus omission of judgment. When we look at, medical negligent cases or clinical negligent cases, it comes down to, did you look at the information? Were you aware of all the information that you should have known? That would be the facts. And then you made a decision. And, juries typically are pretty forgiving of clinicians who knew what the rules were, and they did their best at making a clinical decision, even if it went wrong. What's less forgivable is if you ignored what the rules were or ignored the information that you should have looked at, and then a decision went poorly. So what is always very helpful and necessary is to make sure that you document what your thought process was. So this is why I chose to report. My understanding was this. This is the process that I took. Or, my interpretation was this, and I attempted to reach others, but I wasn't able to, and this is where I landed. And so I think that's probably the most important thing, is that you document your clinical judgment in the record. And so do we have any particular cases that people wanted to talk about? Again, as I mentioned, in a format of Project ECHO, we'll typically, discuss some particular topic, and then we'll ask people from the field, essentially, if you have a particular case or a particular scenario that you wanted to talk about, again, protecting, health information. And let me just say that, one of the other dilemmas that many people come across, particularly those working with individuals who may have an infectious disease, is also, oftentimes substance use goes along with that. And then there's the issue of 42 CFR Part 2 in terms of confidentiality. And when you're divulging information that's necessary for mandated reporting, you want to only divulge what is required or necessary. You don't want to go more than that, again, unless it is necessary. So, again, we have laws looking at, in particular, what's required, who it's required to be reported to, what they need as part of that requirement. But if there are things that they don't need, then we don't divulge that above and beyond. So, Rebecca, when you asked me, or actually, I think it was someone, maybe Julie, someone else asked me, can you talk about the ethics and laws having to do with infectious disease and reporting? Was this kind of what you were looking for, kind of what you were looking at? I don't know who the other individuals are who are beaming in.
Beaming in. Yeah, yes, I think this is what we're looking at. I kind of want to know is there anybody that has any, potential hypothetical cases or things like that, or ethics that you've dealt with? And I also think that part of our discussion was as well around the ethics of, encouraging somebody to make sure that they're getting tested, but then also handling it when you have, maybe even two different clients that are involved in a relationship, and
right.
the status of one and you can't share. And so some of that, it does create some ethical dilemmas in addition to what the law dilemmas are.
Right. And there are actually, North Dakota is not one of the states, but there are 10 states that actually have intimate partner reporting requirements where you are actually legally required to report that to your partner, but North Dakota is not one of those.
So that's good to know. I didn't know that we were not one of those, although I don't know why I didn't. It's surprising to hear that from you.
No. Well, we still have the other clinical obligations, but in terms of whether the legislature has come and said, this state must have this law, it's not one of them. So
that would create kind of if you were a practitioner working with somebody, you can't, that individual is not mandated to let their partners know. But for you as an ethics, for you as a provider, that would be something that you, in my mind, would be using like motivational interviewing and, other techniques to get that person to come to that conclusion on their own.
Right. What do other people think? Have you been in those situations? Wanda, I know you've been in some. You're muted.
Yeah, especially in treatment in the community where we're located. A lot of times we have couples and we separate them, try to get releases of information for each other, or make it a hard and fast expectation that we're not going to be talking about each other.
Right. And again, part of the issue in terms of reporting to the Department of Health, it's also their job to track down contacts and others. Now, the individual might not divulge, et cetera, but it's their job to actually do that as part of their mandate for infectious disease.
So you saying that, I kind of want to hear from some of our Department of Health people, like Jennifer. How do you, do you feel that is, and does that create some ethical dilemmas on your side?
So this is something that we traverse daily in our work lives. So this, in a way, it's a little bit of an old hat for us. So if you have a client that is seeking you for behavioral health services, and you're in Wanda, so was very kind to just let us know that yes, she does see couples a lot. So when Wanda sees a couple and the one of the two discloses, I'm HIV positive, and then is able to find out that no, that person has not told their significant other, which Wanda is still in conversations with. Wanda does not have to breach confidentiality and tell that other person about that their partner's positive. But what Wanda can do to bridge that gap, Wanda can call the health department, because that is ethical to call the health department and say, hey, this individual is seeking, I'm with them, we're seeking care, wanting to connect them maybe with some medical services, wanting to learn more how I can help facilitate things for my client that's disclosed that I'm HIV positive. Okay, if they're HIV positive, and they've had their lab work in North Dakota, the North Dakota Health Department's going to know about it. Okay. And it's okay for you to discuss that with us. We're not going to, just as Dr. McLean said, we're not going to give you a whole bunch of information, because you only need to know what you need to know. You're not going to give me a lot of information, because I only need to know what I need to know. But one of the things that Wanda can say to me is, my client has let me know that they have not yet notified their partner. I know who their partner is. Can you do an anonymous notification to their partner? And yes, we can. That is something that we do day in and day out. It's one of the hardest phone calls that somebody receives, because all of a sudden, they're going about their business, their great, beautiful, sunny day, and the health department gives them a call and says, you may have been exposed. I want to work with you to get you in for some testing and some treatment.
So us on our end, then we could actually have that conversation with the person infected and say that, like, this is what's going to happen. What could potentially happen? How about we have a session together and have this conversation, so the information comes from you versus, some random person calling them on the phone saying, hey, guess what?
Yeah. And again, Wanda, I think that goes back to also our discussion about, safety and your safety. And the vast majority of times, like you said, that's ideal. That would be exactly what you would hope to do. But you wouldn't want to find yourself in a situation where you said, this is what I'm going to do, and this is the consequence that's going to happen. And you weren't prepared for perhaps what the response would be. Jennifer, was there anything in my presentation that you thought, no, that's not accurate, or that's not exactly how it's going, or
Actually, I was quite impressed. I was like, did you call my chief and talk to my chief on our process? Wow, he's got it down.
I did not, but this is what I teach our residents too, in terms of essentially the issues around confidentiality and breaching confidentiality are pretty standard, but yeah, like I said, many states have different rules, but as we know, if you practiced in other states, you know that there are typically pretty common mandatory reporting situations for abuse, et cetera. One of the things I was very surprised about, I no longer do this, but I used to survey for the Joint Commission 1 week a month, and mandatory reporting of child abuse. I was in one state where, unless the abuse was perpetrated by an adult with legal responsibility, it wasn't a mandated report, which seemed just absurd.
That just seems ridiculous.
Yeah, absolutely it did, but that was actually the law. So, again, when you feel you have an ethical obligation, certainly follow your standard of practice, but it's always good to actually know what the laws are within the state in which you're doing so.
I think on the flip side for us at the health department, and what is the whole basis of why we wanted to do this Building Bridges project, is when we're visiting with clients that have an infectious disease, oftentimes we're finding that they have needs that are well beyond our scope of practice. Mm-hmm. And they may or may not disclose to us that they do have somebody that they're working with in behavioral health. And one of the things that are challenges that we come up with, and that we're still building those bridges, it's not done yet, is how can we connect? How can we get that person connected to the right person? If they're not being fully disclosure with us and telling us, yep, I see Dr. McLean at this facility for my for counseling and for my services. If they're not being that forthcoming with us, we're having a difficult time, like connecting the dots for them, because that is a part of what we do, but we also, that's not our scope of practice to do that service, but it is our scope of practice to connect them with the services. And our biggest challenge right now is there any way or any better way that we can find out or give that information to someone within behavioral health that's like, oh yes, you know, that client's on our radar or whatever, and they're being seen by Rebecca at this clinic. Is there any way to facilitate that a little bit easier for us that are with the health department, that are talking with the people that have the infectious disease?
Well, I think, you know, Wanda's crew, the FQHCs obviously are in an ideal situation to, you know, they have a number of services. If you're able to connect with various homeless health places as well, you know, those also would be options, you know, family health center in Fargo, and, you know, other communities may not have those resources. What we're really talking about, Jennifer, is, you know, are there case manager brokers that, you know, are available to be able to do those sorts of things? Like I said, in the FQHCs and the community mental health centers, you know, those are built in. Some of the other situations they're not. And yeah, it does speak to the fractionation of care that we have, or the lack of care access that we have for many people.
You know, we don't want to just call some random person and be like, well, Jennifer Schmidt needs some services.
Right.
Is Jennifer Schmidt on your radar? Because if she's not, she should be. You know, so ethically, that we don't feel right about doing that. But we want to facilitate that.
Right.
So,
well, what you mentioned though, Jennifer, is, you know, if you have the legal ability to say a person's name or do whatever, then you can do that. The receiving party might not be able to acknowledge, but, you know, if you have the legal ability to do that, oftentimes we will say, you know, I can't confirm or deny, but thank you very much. The other thing is, if it actually is a continuity of care issue, then informed consent is not required. Now, it depends on what attorney you talk to, and they get all up in arms about it. But truly, when there are continuity of care issues, informed consent is not required. Now, you obviously always want to be careful about, again, 42 CFR Part 2 or any other non-essential or excessive information. And again, you run into medical records and legal saying, oh, we can't do this. But actually you can, if it's continuity of care. And I'm sorry, there was just something in the chat. Problem I've experienced with that is the inability to confirm means I could be at a dead end and never know it. Yeah, well, so if Rachel, if you're talking about you being the person calling, at least you have notified the group that may actually have that information, be able to do something, unless I'm misinterpreting what you have put in the chat.
The issue that I tend to come up with actually usually involves patients who are at a rehabilitation center,
Yep.
Who may have tested positive or are a partner to somebody. And so they say, yes, I think they're at, I'm going to say Heartview just because that's in my area. So I will say, hey, you know, I'm calling because, you know, I've heard Jennifer may be with you and she was exposed to a partner with HIV, needs some testing. Yep. Well, Jennifer can't answer the phone because she's there, but how do I know now that Jennifer has been warned so that she can receive testing when it cannot be confirmed that she's there? And this person could have been sent to a number of different rehabilitation centers. You know, I can't call everywhere in a tri-state area.
Right. Well, my first point would be, you may have just done your due diligence. You did the best you could. And I would just document, I tried to inform this party that where I suspected Jennifer was. Other than that, you're right. There's not a lot more you can do, except for Jennifer Schmidt. Do you have other thoughts on, letting the Department of Health know? But typically I would just, Rachel,
I should mention that I am with the Department of Health.
Okay. So yeah. So then I would say, you've done your due diligence, that you've informed them. And if they are, they would have an obligation, I would think, to take that information and do what they feel is in the individual's best interest if they are there. And so you've done what you could. I would just document that you did what you could. If there's a negative outcome down the road and somebody comes back and says, I should have been informed, blah, 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 you would be able to say, I did what I could under the rules that we have. It's on them.
Could we say, can I leave my information for you to pass along if this person is in your facility, and have them call me back? I mean, at least we're giving our information out and hoping.
Yeah, absolutely. Yeah.
I like that, these people come into our world with infectious diseases and we're not continually seeing them. Hopefully not anyway, I should say. We're not continually seeing them. So that was a very nice tip. And Rachel is my coworker, and we're the safety net for these infectious diseases. So although you are right, Dr. McLean, of just documenting that you've done everything you can, I can just let you know that myself, and I may be speaking, and I think I can speak for my coworkers on this, we just want to make sure they're okay.
Absolutely.
We just really want to know that their health, their physical health is being taken care of. And we know that they need this test, and it's so easy. And can we come and do it? I mean, that's how we feel. Can we just come?
Oh, absolutely.
But like you said, they can't, as Rachel beautifully described, there's situations where we can't, the facility will not let us know.
Yes.
And that's
right. If the world would only do what we knew what they should do, and probably we don't have the locus of control. That's what's very frustrating, because we know what's best and we know how easy it would be. So I share your misery there, Jennifer. I've been in that situation many times.
Well, and Jennifer, I think more than what you said, like, we want to make sure their physical health is okay to that. But another piece of us doing this this building bridges thing with behavioral health is also so much those of you on the infectious disease side, you also want to make sure their behavioral health is okay. And so often you're seeing cases that you feel it's not being taken care of, but you guys are like, but way out of our scope to manage this, but we want to be able to pass the baton. And so I think on that side, part of this has been that education piece of how can we be doing a better job of kind of bridging that, so that because it's a little bit in both arenas. Like behavioral health has their feet just a little bit in infectious disease because of the overlap and all of those pieces, but also infectious diseases having their feet a little bit in behavioral health and wanting to know, okay, where is the warm handoff?
Yeah. And then, Jennifer, one of the things that I've occasionally done, certainly not frequently, but I think Rachel was alluding to, you call the front desk and you get shut down. You always have the ability to also contact a nurse or the medical director and essentially say the same thing. I mean, if you feel that it's stopping at the front desk, and you're just passionate about, making sure that the right people got the right information, you can always do that.
Yes. So we do typically do that, where we'll ask for the nurse of a facility. Really where we end up with the issue is a lot of times with people that have both behavioral health concerns and infectious disease concerns, finding them is very tricky. So we're not able to confirm that they are indeed, mom might have said they may be at Heartview or they may be at this facility. We have no way of knowing or being confirmed by the facility. Okay, yes, thank you, I'll take that information. And just because they say that they might be at facility A, if facility A was full, depending on their needs, they may be at B, C, D. I mean, I've had folks out of the Belport area that end up as far as Arizona.
Right.
And I can't notify that far. So it is very difficult when we're not able to say that, yes, we did our due diligence, because I could have hit 100% a dead end, and that person may have no chance of being notified.
Right.
So that's kind of where we end up with a big blockade is, you know, if I know for sure they're somewhere, no problem. But
Yes.
I can't call every facility in the United States because
Right.
I've been told that they may be at the rehab.
Yeah. And again, that's a constant dilemma when we look at individual rights versus accessing care, continuity of care. There have been lots of discussions at government levels about how, on the one hand, 42 CFR or other confidentiality issues protect the patient. On the other hand, those regulations prevent them from getting the care that they need or the continuity of care. So Wanda with Epic can see where some patients are in some facilities, but you can't look at HeartView's electronic health record and say, I know that, Rachel is here or that Jennifer is here, whereas in some facilities you actually can. And, I think we're going to continue to hear ongoing debate about, the pluses and minuses of that level of confidentiality.
The best thing I learned today was, Jennifer, I wasn't aware that you could call and basically let it be known, hey, this person might have been exposed. Can you do? I always just thought, I guess it never occurred to me that that was a way of doing that process.
Well, wonderful. Yes.
Yeah.
Reach out to your field EPIs, reach out to your public health counterparts. When you have that situation, not a problem. We got it.
And Rebecca, you bring up a point. What I used to do a lot when it came to mandated reporting in terms of abuse issues, and I was benefited by the fact that the county group doing that review was right upstairs. But I would go up and I would say, let me run a hypothetical by you. And then they would tell me, yeah, actually that's reportable, or this is what you should do. And so even if you're a little skittish and just wondering, you could call up Jennifer or Rachel and say, this is what I'm wondering about. Where should I go with this? Well, thanks.
Absolutely. We follow, we go on trails, down rabbit holes. We look under all the rocks. And so we'll do wild goose chases for you. That's our job. That's what we do, right, Rachel?
Rachel has left the building. Okay. So
Rachel doesn't know how to use her mute button.
Get in line. Yeah. So thank you everybody for participating. Rebecca put the post test in the chat. If you want access to the slides, I'm sure that Rebecca can certainly get them to you.
Yep,
I
sent them out on Monday, but if you didn't get them Monday, I also will send them out again with the evaluation link after the session. So you should get them.
Yeah. So thanks much for your input, and have a good rest of the day.
Thank you, everybody. I will say as well, I did again put the link in there, but we do have the videos up. We are working on nursing CEUs for those, but we do currently have social work and LAC CEUs for those, for the past video ones. So thank you, everybody.